She walked onto my property without permission, stood in front of my door, and told me I had 30 days to tear out the original wood siding that had been on this cabin since 1931, or she would begin legal proceedings to have me fined into compliance. She didn't knock. She announced. I looked at her for a moment. Then I looked past her, at the inspector she'd brought along, at the camera he was holding, at the county road visible just beyond my gate, the gate she had walked through without asking. I didn't say much. I thanked her for coming in person. I told her I'd read the notice carefully. She took that as surrender. I could see it happen in real time, the slight lift of her chin, the way she turned back toward the path without waiting for more. As if a man who didn't argue back was a man who had already decided to comply. She had no idea she'd just handed me exactly what I needed. What she didn't know, what I had no intention of telling her yet, was that the moment she stepped through that gate uninvited, with a camera rolling, she had committed the first in what would become a very well-documented series of mistakes. And I had spent 17 years in federal court watching people like her build their own cases against themselves, one overconfident move at a time. She wasn't the first person who had stood in front of me and mistaken my silence for the absence of a plan. She was just the first one to do it on my property. How sure of yourself do you have to be to look at a man who isn't fighting back and decide he simply has nothing to fight with? I came to Silver Bay because I was tired of being loud. For 17 years, I had worked in rooms where every word carried weight, where silence was a weapon and language was the battlefield. Federal prosecution doesn't leave much space for quiet. You learn to fill every pause, to push, to press, to hold a jury's attention through sheer controlled force. I was good at it. I was very good at it.
And then one case, the kind that gets your name in the wrong headlines for the wrong reasons.
The kind where doing the right thing costs more than anyone warned you. And suddenly the loudness stopped feeling like strength. It started feeling like noise. I requested reassignment. They offered a desk job in D.C. I declined. A former colleague mentioned a property on the market in Silver Bay, Oregon. A lakeside cabin, original structure, nearly a century old, sitting on a half-acre of Douglas fir and silence. I drove out on a Thursday, stood on the dock for 20 minutes watching the water, and made an offer that afternoon. I wasn't running from anything. I want to be clear about that. I was choosing something, a particular kind of life that I hadn't allowed myself in a very long time. I planted a kitchen garden in the first week. I woke before sunrise to walk the tree line. I kept a log of the birds I saw from the dock, a pileated woodpecker on the 4th morning, 2 mergansers by the 11th day. Small things, things that didn't require me to outmaneuver anyone. The cabin needed work, real work, the honest kind. Weathered boards, a stone fireplace that needed repointing, plumbing from the 1970s. I hired a local contractor named Dale who moved slowly and talked even slower, and who told me on the second day that the bones of this place were better than anything built in the last 40 years. I believed him. I started learning the language of the structure, which floorboards creaked, which windows sealed tight in winter, where the light came in best in the morning. It was the first home I had ever paid attention to. That's the thing about a man who has spent his career prosecuting. He is, at the core, a reader of patterns. He is trained to notice what doesn't fit, to track what doesn't add up, to stay calm while cataloging. It's not something you switch off. I wasn't looking for trouble in Silver Bay, but I also wasn't the kind of man who would miss it when it arrived. And when Victoria Hargrove slid that first notice under my door, something in me went very still. Not from fear, but from recognition. I had seen this pattern before. I just hadn't expected to find it at the edge of a lake in Oregon. There's a principle I developed somewhere around my 8th year in federal court, not from a textbook or a mentor, but from watching what happened when prosecutors moved too fast. The instinct, when you have something, is to use it. You find the inconsistency, you locate the leverage, and every nerve in your body says, now, hit now, while it's clean, while you're sure. Most people follow that instinct. Most people are wrong to, because the moment you play your hand early, you do 2 things simultaneously. You show the opponent what you have, and you give them time to adjust. A case that could have been airtight becomes a negotiation. A person who is about to walk into their own trap gets pulled back from the edge. You haven't won, you've warned. And a warned opponent is a contained one. Contained opponents settle for less than they deserve to lose. I learned to wait, not passively, never passively. Waiting, in the way I mean it, is one of the most active things a person can do. It requires you to hold your position while every impulse fires against it. It requires you to keep watching while your opponent keeps moving. Keep documenting while they keep escalating. Keep your voice level while theirs rises. You are not frozen. You are coiled. The rule I settled on was simple. Don't speak until speaking costs them more than staying silent costs you. That morning, after Victoria left my property with her inspector and her camera and her absolute certainty that she had just put a quiet man on notice, I sat at my kitchen table with a yellow legal pad and wrote down everything I had observed. The time she arrived, 8:47 a.m. The fact that she had not knocked at the gate, had not announced herself at the property line. The name on the inspector's badge, which I'd read quickly and committed to memory, the make and color of the vehicle parked on the road, the specific language she had used. Tear out, not replace, not update. Tear out, as if the history of the structure was an inconvenience rather than a fact. I wrote it all down, and I did not call anyone. There are people who would have had a lawyer on the phone before her car reached the end of the road. I understood that impulse. I had spent a career being that person in someone else's story. But I also understood something those people often don't. The first move is rarely the best move. The best move is the one made when the other side has already committed, fully, publicly, irreversibly, to being wrong. Victoria Hargrove had knocked on my door believing she was beginning a process of pressure. She had actually begun a process of documentation. She just didn't know yet that I was the one doing the documenting. There's a difference between a man who hasn't responded and a man who has decided not to respond yet, and the most dangerous thing you can do is assume they're the same person. The cabin wasn't just property to me. I need to say that plainly, because what comes next won't make sense unless you understand what was actually at stake. I had spent the better part of 2 decades living inside institutions, the U.S. Attorney's Office, federal courthouses, government buildings with fluorescent lighting and no windows that opened. I had owned an apartment in D.C. for 11 years and never once learned the name of the family across the hall. That's not an indictment of anyone. It's just the shape a life takes when the work is the whole of it. The cabin was the first place I had chosen entirely for myself, not for proximity to an office, not for the right address, not because a relocation package covered it. I had stood on that dock and felt something loosen in my chest that I hadn't realized had been clenched for years. I had planted things in the ground. I had learned which window let in the first light. I had started, for the first time in a long time, to sleep through the night. Losing it wasn't abstract. The HOA's notice itemized renovation costs that, if I compiled them honestly, would run between $60,000 and $90,000. New siding, updated roofing material, exterior paint within their approved color palette, landscaping brought into compliance with current standards, a dock inspection, and potential reconstruction. The numbers weren't accidental. They were architectural, designed not to improve the property but to make keeping it financially irrational. I had savings. I wasn't desperate, but I also wasn't blind to what those numbers were engineered to do. And beneath the financial pressure was something quieter and more corrosive, the threat of ongoing legal action, fines compounding weekly, the possibility of liens, the slow, bureaucratic suffocation of a homeowner who couldn't afford the time or the legal fees to fight every manufactured violation individually, even if each one was beatable on its own merits. That was the mechanism, not one knockout blow, 1,000 small cuts, each one justifiable in isolation, each one designed to make staying feel harder than selling. I looked out at the water that evening and understood exactly what I stood to lose, and I decided, quietly and without drama, that I was not going to lose it. The only question was how I chose to make sure of that. The second notice arrived 11 days after the first. Not 30 days later, not after any reasonable window for response or compliance. 11 days. And this one cited 3 additional violations that hadn't appeared in the original letter. A storage structure at the rear of the property that allegedly exceeded height allowances. A section of fencing described as non-compliant with updated aesthetic guidelines, and what the notice termed unregistered external modifications to the cabin's north-facing wall. That last one referred, as best I could tell, to a wooden window box I had installed the previous week to grow herbs. A window box. I set the second notice next to the first on the kitchen table and looked at them side by side. Then I went to find my neighbor. Frank DeLuca had lived on the lake for 22 years, retired electrician, kept a vegetable garden that ran the full length of his south fence, and waved every morning from his porch without fail. He was the first person in Silver Bay who had made me feel like a resident rather than a newcomer. I knocked on his door that afternoon and asked him, as casually as I could manage, whether he'd had any recent dealings with the HOA. He was quiet for a moment. Then he invited me inside. What he described over the next 40 minutes was not a neighbor dispute or an isolated grievance. It was a pattern. New bylaws appearing in the annual mailer with no prior vote, no meeting, no homeowner input. Fee increases framed as routine adjustments. Inspection notices for properties that had never been cited in decades of prior HOA oversight. Almost always the older homes, the original structures, the ones closest to the water. 3 families in the past 14 months had sold. 2 of them, Frank said, had told him privately they felt they had no other option. I asked him who had bought those properties. He said he didn't know exactly. A holding company of some kind. He'd seen the signage go up within weeks of each closing. The same design, the same typeface, a name he didn't recognize. I thanked him and walked home slowly along the tree line, turning the shape of it over in my mind. This wasn't about my window box. It was never about my window box. Victoria Hargrove wasn't enforcing community standards. She was running a pressure campaign, and she had been running it long before I arrived. My cabin was simply the newest entry on a list that had been growing for over a year. I could have confronted her with that observation the next morning. I didn't, because an observation isn't a case. And I had learned a long time ago never to accuse someone of a pattern until you can prove every single stitch of it. She wasn't done yet, and neither was I. Have you ever watched someone build a trap for themselves, one careful step at a time, and understood that the most powerful thing you could do was simply not warn them? 3 days after my conversation with Frank, I ran into Victoria Hargrove at the post office. She was standing at the counter when I walked in, speaking to the clerk in the particular tone of someone who considers small transactions beneath them, but performs them anyway as a demonstration of civic participation. She was dressed precisely: pressed linen, a silk scarf, hair that suggested a standing appointment somewhere in town. Everything about her said, "I am a person who has arranged things to her satisfaction." She turned when she heard the door and looked at me with an expression I recognized immediately. It was the look of someone who has sent 2 notices and received no response, and has decided that means the situation is resolved. "Mr. Cole," she said, pleasantly, almost warmly. "Ms. Hargrove," I said. She asked how I was settling in. I told her the lake was beautiful. She agreed and mentioned, almost in passing, that she hoped I was finding the community guidelines straightforward, that they were really designed to protect everyone's investment, and that most new residents appreciated the clarity once they understood the vision for Silver Bay. I looked at her for a moment. I had, in my inside jacket pocket, a printed page from the Oregon Revised Statutes regarding homeowner association bylaw amendments. Specifically, the section requiring a ratified membership vote before any new enforcement provision could carry legal weight. I had pulled it 2 nights earlier from the county's public records portal, cross-referenced it with the HOA's own filed documents, and found what I had suspected since the first notice arrived. At least 4 of the 7 cited violations referenced bylaws that had been amended in the past 18 months without any recorded membership vote. I could have placed that page on the post office counter right then. I could have named the specific statute, cited the amendment dates, and watched her expression change in real time in front of a witness. I chose not to. Not because I doubted what I had. I didn't. I chose not to because she was still being careful, still polished, still deniable, still operating in a register that could be walked back if cornered too early. One printed page in a post office wouldn't end this. It would only put her on guard. She would adjust, tighten, cover what could still be covered. What I needed was not her retreat. I needed her full advance. So I smiled and told her the guidelines seemed thorough. I said I was still reviewing everything. I told her I appreciated her stopping to speak with me in person. She left the post office looking satisfied. I stood at the counter for a moment after she walked out, listening to the sound of her car pulling away, and thought, not yet. That afternoon, I ordered a weatherproof document camera and a secondary external hard drive. Both arrived within 48 hours. How much restraint does it take to hold a winning card and wait? Not because you're unsure, but because playing it now would only save your opponent from the rest of their own mistakes. Over the next 2 weeks, I said very little and watched a great deal.
I attended the monthly neighborhood coffee that Frank mentioned. A loose gathering at the community pavilion, mostly longtime residents, mostly people who had been here long enough to remember when the HOA was a volunteer group that organized the 4th of July cleanup and nothing more. I didn't speak much. I asked a few questions. I listened to the pauses as much as the answers. What I heard, underneath the careful politeness of people who still had to live next to each other, was exhaustion. A woman named Patrice, who had owned her home for 16 years, mentioned offhandedly that she'd received 3 notices in the past 5 months, the most recent for a flagpole that had been in her yard since her husband planted it the year he retired. A retired teacher named Howard said he'd stopped planting flowers along his front fence because he wasn't sure anymore what would trigger an inspection. A younger couple near the east end of the lake had quietly removed a children's play structure rather than deal with the paperwork. Nobody was fighting back, not because they didn't want to, but because each violation, in isolation, felt too small to justify the cost of resistance. That was the elegance of the system Victoria had built. Every individual grievance was manageable. It was only when you laid them side by side that the shape of the thing became clear. I laid them side by side. I kept a running log in a green notebook. Dates, names, notice numbers, property addresses, amounts cited, bylaw references. Each entry was dry and factual, but by the end of the second week, the notebook had become something more than a record. It had become a map. Victoria, for her part, had gone quiet. No new notices for 11 days. I suspected she was interpreting my continued silence as compliance in progress. She was wrong. I was simply still counting. On a Tuesday morning, I drove to the county records office in Millhaven. Not a lawyer's office, not a courthouse. The county records office, a low-ceilinged room on the second floor of the municipal building that smelled of old paper and floor cleaner, staffed by 2 clerks who looked mildly surprised anyone had come in before 10. I told them I was researching the property history of a cabin on Silver Bay and asked for everything they had: deed records, zoning classifications, any historical designations on file. The clerk, a woman named Ruth, who moved with the unhurried confidence of someone who has never once been in a rush, disappeared into the back room and returned 20 minutes later with a manila folder that was thicker than I expected. I sat at the reading table by the window and went through it page by page. The cabin had been built in 1931 by a family named Calloway, one of the original lakeside homesteads in the area. In 1987, as part of a county-wide preservation initiative, it had been formally designated a protected historical structure, a designation that carried with it a specific set of exemptions from later enacted local regulations, including, explicitly, homeowner association aesthetic guidelines adopted after the designation date. I read that paragraph 3 times. Then I took a photograph of every relevant page with my phone, thanked Ruth, and drove home along the lake road with the windows down. That evening, I set up the document camera on the kitchen table and began building a proper file.
the county records. The HOAs filed bylaws from their original incorporation, which I had requested separately and received by mail the previous week. The amendment records, or rather, the absence of the amendment records that should have accompanied each bylaw change. The notices I had received, Frank's account, which I had written up in clean summary form after our conversation, Patrice's flagpole, Howard's Flowers, the holding company name I had pulled from 2 of the recent property transfer records at the county office, cross-referenced against the Oregon Secretary of State's business registry. The company was registered 18 months ago, 2 months before the first wave of amended bylaws, 1 month before the first old property notice had gone out. I wrote that sequence down in the green notebook and underlined it once. I didn't need to underline it twice. The line was already there. The third notice arrived on a Friday. This one included a fine, $420, itemized across 3 violations, due within 21 days. At the bottom, a single line in slightly heavier typeface. Continued non-compliance will result in escalating penalties and potential referral to county enforcement. I noted the date, photographed the envelope and its contents, and placed it in the file. That same weekend, 2 men I didn't recognize appeared at the edge of my property with a measuring tape and a clipboard. They didn't knock. They didn't announce themselves. They walked the perimeter of my dock, measured something along the north fence line, wrote things down, and left without making eye contact when I stepped onto the porch to watch them. One of them had a badge clipped to his jacket that said Silver Bay HOA, Property Standards. I let them measure. I watched from the porch with a cup of coffee and said nothing, but I had the document camera running from the kitchen window, angled toward the yard, and it recorded 41 minutes of footage that included both men's faces, the badge, the measuring tape, and the moment one of them reached over my fence line to press the tape measure against the exterior wall of the cabin. That last moment, the reach across the property boundary, I flagged with a timestamp note in the green notebook. Frank called me that evening. He'd seen the men leaving and wanted to make sure I knew who they were. I told him I had a sense of it. He was quiet for a moment, then said something I didn't forget. Most people, when this starts, figure it's easier to just go along. He paused. I never thought you were most people. I thanked him and didn't explain what I was doing. Not because I didn't trust Frank. I did. But because the fewer people who knew the shape of what I was building, the less chance there was of any of it reaching Victoria before I was ready. The fine sat in the file unpaid. The clock was running. So was I. The HOA held an informal community update at the pavilion on a Thursday evening in late October. I went. I sat near the back, said nothing, and listened. Victoria ran the meeting with the practiced ease of someone who had done this many times and enjoyed it. She moved through agenda items briskly: upcoming landscaping standards, holiday decoration guidelines, a proposed increase to the quarterly maintenance fee. The dozen or so residents present nodded along with the particular expression of people who have learned that engagement costs more than compliance. Then, near the end, she brought up what she called ongoing enforcement matters. She didn't use my name. She didn't need to. Everyone in the room knew who had recently moved into the old Callaway cabin, and everyone in the room had presumably seen the inspection team on my property the previous weekend. She said, with a measured smile, that she was pleased to report most new residents came to understand the community standards quickly once the process was explained properly. She said that, in her experience, initial resistance almost always gave way once homeowners realized the guidelines existed to protect their own property values. She said, and here she paused just long enough for it to land, that she found the ones who stayed quiet longest were usually the ones who, on reflection, recognized they didn't have a strong position to argue from. The room was silent for a moment. I looked at my hands on the table. I thought about the file sitting on my kitchen counter, the county designation records, the bylaw amendment gap, the footage of her inspector reaching across my property line, the business registry printout with its 18-month-old incorporation date, the green notebook now running to 31 entries. I thought about the column of names Frank had quietly confirmed for me: 3 former neighbors, 3 sold properties, 1 holding company. I thought about all of that. and I kept my hands still and my face neutral, and I said nothing. Victoria glanced in my direction once, briefly, with an expression that I can only describe as confirmation, as if my silence had just proven her point to the room. That glance told me everything I needed to know about where she believed we stood. She thought she had already won. I noted the exact words she had used, didn't have a strong position to argue from, in the green notebook that night, with the date and time and the names of the residents present. Evidence isn't just documents. Sometimes it's a sentence spoken in the wrong room at exactly the wrong moment. She had just given me one of each. What does it cost a person to sit in a room where someone publicly mistakes their silence for defeat and say nothing because they know the real answer is coming, just not yet? 2 days after the pavilion meeting, I received a certified letter. Not from the HOA this time, from a law firm in Portland. Marsh, Alcott, and Webb. 3 names on cream-colored letterhead that radiated the particular confidence of people who bill by the 6-minute increment. The letter informed me that the Silver Bay Homeowners Association had retained their firm to pursue enforcement action regarding my outstanding violations and unpaid fine. It outlined a timeline: 10 days to respond in writing, 21 days to demonstrate material compliance, or they would proceed to file a formal complaint with the county and seek a lien against the property. A lien against a cabin I had owned for less than 3 months. I read the letter twice, set it down, and called an attorney I trusted. A woman named Carol Reyes, who had worked property and land use law in Oregon for 20 years, and whom I had known since a federal case that had briefly touched her county a decade prior. I explained the situation in broad strokes. She listened without interrupting, which was one of the things I respected most about her. When I finished, she was quiet for a moment. Then she asked me 2 questions. First, had I looked up the historical designation status of the property? I told her I had, and what I'd found. She made a sound that was not quite a laugh, but was adjacent to one. Second, had I documented the unauthorized entries? I told her about the footage, the timestamps, the green notebook. This time the sound was closer to satisfaction. She told me to send her the county designation records and the HOA's original and amended bylaws. She said she'd review them over the weekend and come back to me with a formal assessment, but that, based on what I'd described, she had serious questions about the enforceability of at least half the cited violations, and potentially significant questions about the firm's ability to pursue a lien against a historically designated structure without triggering a separate layer of county review. I thanked her and told her I wasn't ready to move yet. She paused. Then she asked, carefully, whether I understood the lien timeline. I told her I did. She said she would prepare a holding response, something that acknowledged receipt of the firm's letter without conceding any ground, that I could send within the 10-day window to stop the clock without showing our hand. That letter went out on day 9. Marsh, Alcott, and Webb acknowledged it within 48 hours. The timeline paused, but the pressure didn't. The following week, a county building inspector appeared at my property. Not an HOA contractor this time, but an official county inspector. Badge and clipboard, and a printed work order that listed my address and cited 2 structural concerns flagged by a third-party complaint. The complaint, as far as I could determine, had originated from the HOA. I let him inspect. I walked him through the property calmly, answered every question, and provided him with the county's own historical designation file, which I had printed and kept in a folder by the door specifically for this eventuality. He reviewed it for several minutes, made some notes, and told me he would need to consult with the county preservation office before proceeding. He left without issuing any finding. I closed the door, stood in the kitchen for a moment, and updated the green notebook. The system was fully in motion now. Victoria had pulled every available lever: HOA notices, private attorneys, third-party inspectors, county referrals. She was playing the board hard, confident, the way a person plays when they believe the other side has already folded. She had not yet looked carefully enough at who was sitting across from her. It was Frank who first said it out loud, though not to me directly. I learned about it secondhand from Patrice, who had been standing in Frank's driveway when he said it to his wife the evening after the county inspector's visit. She told me about it a few days later, almost apologetically, as if she wasn't sure whether I'd want to know. What Frank had said was this: "That man knows exactly what he's doing. He's just not doing it yet." I didn't respond when Patrice told me. I just nodded and asked if she wanted more coffee. But I thought about it for the rest of that afternoon because it mattered in a way that went beyond Frank's opinion of me. It meant the shape of what I was doing was visible, at least to someone who had been watching long enough and carefully enough to read it correctly. Frank had lived on this lake for 22 years. He had seen 3 neighbors sell under pressure. He had watched enough of Victoria's process to recognize when something different was in front of him that it was different. What he hadn't done was say anything to anyone who might pass it back to Victoria. I was grateful for that. And I was aware it was a fragile thing, the kind of discretion that holds until it doesn't, until someone asks the right question at the wrong moment, or says something at a community meeting that tips the hand before the hand is ready to be played. I stopped by Frank's place that weekend with a jar of the tomato preserves I'd put up from the kitchen garden. We talked about the weather and the state of the dock at the public boat launch, and nothing of consequence. Before I left, I told him, quietly and without elaboration, that I'd appreciate it if he kept his observations about me to himself for a little while longer. He looked at me for a moment with the steady eyes of a man who has spent a lifetime reading voltage and knows when a current is live. Then he said, "How long?" I said, "Not much longer." He nodded once and went back inside. That was the entirety of the conversation. It was enough. The annual HOA meeting was scheduled for the second Saturday of November. I had known about it since my 3rd week in Silver Bay. It was listed in the community calendar tucked inside the original HOA welcome packet, the one Victoria's assistant had left in my mailbox the day after I closed on the property. I had circled the date in pencil the first time I read it, not because I had a plan yet, but because I understood instinctively that a public meeting with mandatory homeowner notification was the kind of event that carried its own legal weight. Whatever was said in that room, whatever was voted on, whatever was presented as policy or precedent, all of it would be on record. That meeting was now 19 days away. Carol called me on a Monday with her formal assessment. Her conclusion, stated in the careful language of a lawyer who chooses words the way a surgeon chooses instruments, was that the HOA's amended bylaws contained at minimum 3 provisions that failed to meet Oregon's requirements for valid homeowner association rule changes. Specifically, the absence of any recorded membership vote for amendments enacted after the original incorporation. She said the historical designation on my property created an additional exemption layer that undermined at least 4 of the 7 original violations entirely. And she said the unauthorized entries, the unannounced inspectors, the men with the measuring tape, the reach across the property line captured on footage, constituted a documentable pattern of trespass that could support a formal complaint. She asked me again whether I was ready to move. I told her I wanted to wait for the annual meeting. There was a pause. Then she asked why. I told her that a letter from an attorney, however well constructed, would be read by Victoria alone, in private, with time to adjust and respond and reframe. A presentation of the same facts at a public meeting, in front of residents, in front of anyone with standing who happened to be present, was a different matter entirely. What could be quietly managed in correspondence could not be quietly managed in a room full of witnesses. Carol said she understood. She said she would prepare a full documentation package and have it ready before the meeting date. She also mentioned, without my asking, that the county's HOA compliance office occasionally sent representatives to annual meetings when outstanding enforcement matters were on the agenda. I asked her how one would go about ensuring that happened. She told me there was a formal written request process. She said she'd handle it. I thanked her and stood at the kitchen window for a long moment after the call ended, looking out at the lake. The water was very still. The heron was back on the dock, in exactly the same position I had seen it the morning of the first notice. 19 days. When you can see the finish line and you're the only one who knows where it is, does waiting feel like patience Or does it feel like something closer to certainty? With 12 days until the annual meeting, Carol sent me the documentation package. I printed it at the library in Millhaven. 43 pages, organized into 4 sections with tab dividers, the way I had always prepared case files. I drove home along the lake road with it on the passenger seat and spent that evening going through every page at the kitchen table with a highlighter and a red pen. What Carol had assembled was not a complaint. It was a chronology. And chronologies, in my experience, are the most persuasive documents in existence, not because they argue, but because they simply place things in order and allow the sequence to speak for itself. The first section covered the bylaw amendments. Carol had obtained the HOA's complete filing history from the Oregon Secretary of State's office, original incorporation documents, annual reports, every amendment submission on record. She had flagged 6 amendment filings from the past 22 months. Against each one, she had noted the Oregon statute requiring membership ratification, and against each one, she had written the same 2 words in clean block letters. No record. No meeting minutes. No membership vote. No ratification notice. 6 amendments enforced as binding community law, with no legal foundation beneath any of them. The second section was the historical designation. The 1987 County Preservation Certificate for the Callaway Cabin, my cabin, was reproduced in full with the relevant exemption language highlighted in yellow. Carol had also included a County Preservation Office memo from 2019 reaffirming the designation's continuing validity and explicitly noting that HOA aesthetic guidelines adopted after 1987 did not apply to designated structures without a separate county waiver. No such waiver had ever been requested. No such waiver existed. The third section was the trespass documentation. Dates, times, footage stills, the timestamp log from the document camera, the green notebook entries, 37 of them now, and a 1-page legal summary of Oregon trespass statutes as they applied to HOA-directed inspections on private property without prior written notice or owner consent. The fourth section was what Carol had quietly titled Contextual Financials. The holding company, registered 18 months ago under the name Lakeview Property Partners LLC, had, in that period, acquired 4 properties within the Silver Bay HOA boundary. Carol had cross-referenced the acquisition dates against the bylaw amendment dates. In 3 of the 4 cases, the property had sold within 60 days of a significant escalation in HOA enforcement activity. She had also found, through public business registry records, that one of Lakeview Property Partners' 3 listed directors shared a surname with a member of the Silver Bay HOA board. Not Victoria's surname. A board member named Clifton Reese, who had served as HOA treasurer for the past 2 years. I sat with that page for a long time. It wasn't proof of conspiracy in the legal sense, not yet, not without more, but it was the kind of connection that, placed in front of a room full of residents who had been receiving escalating violation notices for 18 months, would be very difficult to explain away with the usual language of coincidence. I added one final entry to the green notebook that night. All pieces confirmed. Meeting in 12 days. 5 days before the annual meeting, Marsh, Alcott, and Webb filed the lien. Carol called me at 7:15 in the morning. Her voice was controlled, professional, but I had known her long enough to hear the tension underneath it. She said the filing had come through the county recorder's office the previous afternoon, a formal lien notice against the property for the unpaid fine plus accrued penalties, totaling now just over $1,100. The filing itself was procedurally valid on its face. Contesting it would require a separate legal action that could take weeks, possibly longer, and in the interim, the lien would appear on the property record, which meant, among other things, that I could not sell, refinance, or transfer the property cleanly until it was resolved. I stood at the kitchen window and listened, and said nothing until she finished. Then I asked whether the lien affected the annual meeting. She said no. The meeting was a community governance matter. The lien was a separate proceeding. They ran on parallel tracks. I told her we were staying the course. She said she understood. Then she said, carefully, that I should know the lien was now a matter of public record. Anyone who searched my property would see it. I told her I understood. She said she'd file a formal contest notice to establish our objection on record, which would prevent the lien from being treated as uncontested. I told her to proceed. After the call, I sat at the kitchen table for a while and didn't open the documentation package or the green notebook. I just sat. A lien on the cabin, on the first home I had chosen for myself, on the structure that had stood on this lake for 93 years and that a county preservation certificate had specifically protected from exactly this kind of institutional pressure, filed by a law firm retained by a woman whose entire enforcement apparatus rested on bylaw amendments that had never been legally ratified, in service of a property acquisition scheme that was now documented in 43 pages sitting in a tab-divided folder 6 inches from my left hand. I won't pretend it didn't land. It did, not because I believed it would hold. I didn't. But because there is something particular about seeing your home encumbered on a public record, something that sits in the chest differently than a letter or a notice or an inspector on your lawn. It was the most concrete thing Victoria had done, the most real, the most designed to feel permanent. That evening, Frank appeared at my door with a bottle of decent whiskey and no explanation. We sat on the porch and watched the water go dark and didn't talk about the lien directly. At one point, he said that, in his experience, the people who moved hardest right before the end were always the ones who could feel the ground shifting. I didn't respond to that, but I thought about it for a long time after he left. She had filed the lien because she was confident, or because she was no longer as confident as she appeared, and this was the move of someone pressing harder to compensate. Either way, she had now done the one thing I had been waiting for her to do. She had gone fully, formally, and irreversibly on record. 4 days until the meeting. The documentation package was ready. Carroll's county compliance request had been confirmed. The green notebook had 39 entries. I went to bed at 10 o'clock and slept without difficulty. Is there a lonelier feeling than being right about something that hasn't been proven yet, and knowing the only thing standing between you and the proof is time? The night before the meeting, I didn't review the documentation package. I had been through it enough times that the page numbers had become muscle memory. I could have recited the bylaw amendment dates in sequence, named the acquisition dates for all 4 Lakeview properties, cited the relevant Oregon statutes from recall. There was nothing left to learn from another pass through the file, so I closed the folder, set it on the counter next to my keys, and went outside to sit on the dock. The lake was quiet. A thin line of cloud cover softened the moonlight, and the water held the sky's reflection in long, still bands. I sat with my feet near the surface and thought about why I had come here in the first place. There had been a case, the last one, the one that ended my time in Washington, involving a mid-level official who had been systematically defrauding a federal housing program for 6 years. The victims were not dramatic. They were ordinary people. Families who had applied through proper channels for assistance they were entitled to, whose applications had been quietly redirected, whose names had been used to generate paper approvals that fed a private account. Nobody had been physically hurt. The fraud was clean and technical and entirely invisible to the people it harmed, because the thing taken from them was something they had never quite held in their hands: access, opportunity, the quiet assurance that the system would treat them fairly. I had prosecuted that case and won it, and then the political circumstances around it had become complicated in ways I was not willing to navigate on the terms being offered, and I had walked away from the office I had worked toward for the better part of my adult life. What Victoria Hargrove was doing on this lake was not identical to that case, but the architecture was the same, the mechanism was the same. Take something people are entitled to, their homes, their stability, their right to stay, and apply institutional pressure so precisely calibrated that each individual act seems almost defensible in isolation. Make the cost of staying feel greater than the cost of leaving. Do it quietly enough that no single victim can see the whole shape of it. Frank had stayed. Patrice had stayed. Howard had stayed. 3 others hadn't. I thought about those 3 families sitting in whatever places they had moved to after Silver Bay, and whether they had ever fully understood what had been done to them, or whether they had simply absorbed it as bad luck and moved on. I wanted the answer to be different for the people still here. That was why I had waited, not for strategy alone, though the strategy was real and necessary, but because the moment needed to be one that couldn't be walked back, couldn't be quietly settled, couldn't be made to disappear into a private negotiation that left everyone else exactly where they were. Tomorrow had to count for more than just me. The community pavilion held perhaps 40 people comfortably. That Saturday morning, it held 53. I had arrived early and taken a seat in the third row, the documentation package on the table in front of me, Carol seated to my left. She had driven up from Portland the previous evening and was dressed the way lawyers dress when they want a room to understand without being told that the proceedings have become serious. A county compliance officer named Dennis Warfield sat 2 rows behind us. Carol had confirmed his attendance the previous afternoon. He had a notepad and a government-issue lanyard and the particular expression of a bureaucrat who has learned to betray nothing in advance. Frank was in the back row. Patrice was beside him. Howard had come, which surprised me. He had seemed, in our brief conversations, like a man who had made his peace with keeping his head down. But he was there, coat buttoned, hands folded, watching the front of the room. Victoria opened the meeting at 10 o'clock precisely. She moved through the preliminary items with her usual efficiency. Treasurer's report, upcoming maintenance schedule, a proposal to expand the approved exterior paint palette by 4 colors. Clifton Reese, the treasurer, read figures from a prepared sheet without looking up.
The room was attentive and quiet, in the way rooms are quiet when people are waiting for something they haven't named yet. After approximately 20 minutes, Victoria introduced what she called the enforcement update. She described the HOA's ongoing efforts to bring several properties into compliance with current community standards. She used the word investment 4 times in 3 minutes. She said the board was committed to protecting Silver Bay's character and long-term property values. She said that while enforcement was never pleasant, it was a necessary function of responsible community governance. Then she said that in one particular case, the board had been compelled to pursue formal legal remedies, including a recently filed property lien, and that this action had been taken reluctantly but necessarily after extended non-compliance. She did not look at me when she said it, but everyone else in the room did. I waited until she finished. I waited a full beat after that. Then I raised my hand. Victoria looked at me with the measured patience of someone who has already decided how this interaction will go. She said the floor would be open for resident questions after the formal presentation. I said I had a matter of community governance that I believed was relevant to the current agenda item, and that I would like to raise it while the enforcement discussion was open. I said it calmly, without heat, in the tone I had used 1,000 times in federal courtrooms when I wanted a judge to understand that what was about to happen was going to be orderly and was going to happen regardless. Victoria paused. Then she said I could have 2 minutes. I stood up, opened the documentation package to the first tab, and began. I didn't accuse. I didn't argue. I didn't raise my voice. I did what I had always done best. I placed things in sequence and let the sequence do the work. I told the room that the Silver Bay HOA had filed 6 bylaw amendments in the past 22 months. I held up the first document, the Oregon statute requiring membership ratification for any binding amendment, and read the relevant provision aloud, slowly, so that every person present could follow it. Then I held up Carol's filing history summary and stated plainly that not one of the 6 amendments had any record of membership vote, meeting minutes, or ratification notice. I said that under Oregon law, this meant those amendments were not legally binding, and that every violation notice issued under those amendments, including the one that had generated the lien against my property, rested on a foundation that did not legally exist. The room was very still. I moved to the second tab. I explained the 1987 historical designation on the Callaway cabin, my cabin, and the county preservation memo confirming its continuing exemption from later HOA aesthetic guidelines. I noted that no county waiver had ever been sought or granted. I said this meant that even if the amended bylaws had been properly ratified, which they had not been, the majority of the violations cited against my property would still have been unenforceable. I heard someone in the back row say something quietly.
I didn't pause. Third tab. I described the unannounced inspections, the dates, the footage, the reach across the property line. I referenced Oregon trespass statute. I did not editorialize. I simply noted that the documented entries onto my property without notice or consent constituted a pattern that I had preserved in full. Then I turned to the fourth tab. I told the room that Lakeview Property Partners, LLC, had been incorporated 18 months ago. I told them it had acquired 4 properties within the HOA boundary in that period. I told them that in 3 of those 4 cases, acquisition had followed within 60 days of significant HOA enforcement escalation against the selling homeowner. And I told them that one of Lakeview Property Partners' listed directors shared a surname with the current HOA treasurer. I looked at Clifton Reese when I said that last part. He was looking at the table. I did not say the word fraud. I did not say conspiracy. I did not say scheme. I had learned long ago that the most powerful presentation is one that draws no conclusions, that simply arranges the facts with enough clarity that every person in the room draws the same conclusion independently and believes it is their own. Victoria spoke then. Her voice was steady, but something in the register had shifted, a half-tone tighter, a half-beat slower. She said that the matters I was raising were complex, that the board took governance seriously, that any concerns about amendment procedures would be reviewed by legal counsel. I said, still standing, still calm, "Ms. Hargrove, I didn't raise these matters for review. I raised them because the residents in this room have a right to know that the enforcement actions taken against them and their properties for the past 18 months may have no legal standing, and that someone in this room may have a financial interest in the outcome of those actions." Silence. Then Dennis Warfield, the county compliance officer 2 rows back, uncapped his pen and wrote something on his notepad. That sound, a single pen on paper in a quiet room, was the loudest thing I had heard in months. Patrice spoke first, then a man near the window I didn't know by name. Then Howard, slowly, carefully, describing his flowers and his fence and 3 notices over 14 months. Then 2 more voices. Then 4. The room did not erupt. It opened, the way a room opens when people who have been holding something in private finally understand they are not alone in holding it. Victoria attempted to restore order twice. The second time, Miss Warfield stood and said, in the measured tone of a man whose job is to exist at exactly this kind of intersection, that he would be recommending a formal county compliance review of the HOA's amendment procedures and enforcement records, effective immediately, and that the annual meeting minutes would be submitted as part of that record. I sat down. Carol placed her hand briefly on the documentation package and said nothing. She didn't need to. I looked at the folder on the table. 43 pages, 4 tab dividers, 39 notebook entries, 41 minutes of footage, 1 county designation from 1987, and 1 pin moving on 1 notepad 2 rows behind me. 11 weeks of patience, 1 morning to spend it. If you had been in that room, not as the person who waited, but as one of the people who finally heard the whole story for the first time, what would you have felt in the moment you realized you hadn't been alone? The county compliance review was opened formally the following Monday. Within 3 weeks, the HOA's 6 unratified bylaw amendments were suspended pending investigation. The lien against my property was vacated. Carol filed the removal order on a Tuesday morning and sent me a copy by email with no subject line, just the attachment. I printed it, added it to the documentation package, and placed the whole folder in the bottom drawer of the kitchen cabinet. Underneath it, I put the green notebook. Marsh, Alcott, and Webb withdrew from the matter quietly, without explanation, which is what law firms do when the ground beneath a client's position becomes difficult to stand on. Clifton Reese resigned from the HOA board 12 days after the meeting. The resignation letter, which Frank obtained somehow and read to me over the phone, cited personal reasons and a desire to spend more time with family. Victoria Hargrove did not resign immediately. She held on for another 3 weeks,
issuing 2 brief statements about her commitment to the community and her confidence in the HOA's legal compliance. Then, on a Thursday afternoon with no public announcement, she stepped down. The county investigation into Lakeview Property Partners, LLC, was ongoing as of the last update Carol gave me. She said these things moved slowly and there were no guarantees of outcome. I told her I understood. What mattered to the people on this lake was not the eventual legal destination, but the immediate one. The enforcement machine had stopped. The notices had stopped. The inspectors had stopped appearing on lawns without warning. The pressure that had been tightening for 18 months had simply, abruptly, ceased. Patrice replanted her front fence line in the spring, tulips and lavender running the full length of the property. I saw her out there on a Saturday morning with her hands in the soil and the particular expression of someone reclaiming something small that had been taken from them, and I thought that was perhaps the most accurate measure of what the meeting had accomplished. Not the legal filings or the board resignations or the investigation, but a woman planting flowers again without checking first whether someone was going to send her a notice about it. Howard stopped by one afternoon in early December with a coffee cake and an awkwardness that I found genuinely touching. He sat at my kitchen table and said, after a long pause, that he wished he had spoken up sooner. I told him that speaking up at the right moment was worth more than speaking up early, and that the right moment had required everyone in that room, including him. He seemed to need to hear that. I was glad I said it. The cabin is quiet now in the way I originally came here for. The kitchen garden is dormant through winter, but the soil is good. The heron is still on the dock most mornings, and I have stopped being surprised by its patience. I understand it better than I used to. The next time you mistake someone's silence for weakness, ask yourself what they might already know and what they might simply be waiting for the right moment to say.